Hello and welcome to the feedback video regarding Assignment Legal 1 Planning Law. My name is Fred Hopma and I will discuss the correct answers for this first legal assignment. Okay, let's take a look at the fictional case for this assignment. It reads as follows. Schiphol Airport Amsterdam is a much used airport. However, it has reached its maximum capacity. Therefore, national government has proposed to relocate the airport to a new island in a lake in the surroundings, the Markermeer. And you can see on the map where the Markermeer is. This case is fictional. However, in the past, quite often it was discussed if Schiphol Airport indeed had to be removed to the Markermeer. And even recently there was a discussion to relocate the airport to the Markermeer or to the North Sea. Anyway, the case continues. The city of Amsterdam supports this idea. After relocation of the airport, a lot of land will become available for redevelopment, in particular for much needed residential areas. Note, Markermeer is a so-called Natura 2000 area and thus protected under the EU Habitat Directive. National government of the Netherlands will build a new national high-speed railway from railway station Amsterdam Central to the new airport in the Markermeer. Okay, this is the case. We have 5 questions and each of the questions can be rewarded with 10 points. So the total number of points for this assignment is 50. Let's go to the first question. The fact that the Markermeer is an area appointed as a protected area under the Habitat Directive will certainly raise concerns with environmental groups. At which stages of decision-making do these environmental groups have the power to influence the decision-making? Well, there are 2 good answers to this question. The first correct answer focuses on the high-speed railway, so the construction of the high-speed railway and the stages in which the environmental groups can influence the decision-making regarding the high-speed railway. And the second correct answer focuses on the planning of the new airport. Each of the correct answers could get 10 points. Well, some students mentioned both correct answers, and that's excellent. However, in total, the maximum number of points for this question is 10. Let's take a look at the first correct answer. And this one relates to the high-speed railway. A national high-speed railway falls under the procedures of the Infrastructure Planning Act. This act holds several stages in which the decision-making can be influenced by societal organizations like the environmental groups. First, there is the exploratory phase. In this phase, input is given by participants from different parts of society. Surely, environmental groups will be consulted, and so they can influence the decision-making by their advices and their input. Second, the draft structure vision. Article 4 of the Infrastructure Planning Act explains that societal organizations have to be involved in the preparation of the draft of the structure vision. Well, this may well refer to environmental groups. They too are societal organizations. Third possibility to influence the decision-making by environmental groups, the views regarding the draft of the structure vision. Article 6 of the Infrastructure Planning Act stipulates that everybody has the opportunity to bring forward views which are commons. So also environmental groups have the power to do so, and by their views can influence the decision-making. Fourth, views regarding the draft track decision. Article 11 of the Infrastructure Planning Act specifies that organizations and special interest groups can bring forward their views, so objections or comments, on the draft of the track decision. This includes environmental groups. Fifth, pressure on members of Second Chamber of Parliament if the track decision is discussed in Parliament. Quite often track decisions are discussed in Parliament, and here the environmental groups can put pressure on the members of Parliament. They can contact them so they can influence the voting and the discussions by the members of Parliament. Finally, appeal with the Council of State. A final chance to influence decision making is in court. Interested parties have the power to lodge appeal with the Council of State, and the environmental groups may very well qualify as an interested party. Well, in the book Planning and Development Law in the Netherlands, this is explained in chapter 6. So there are 6 moments to influence the decision making. 5 was enough to get 10 points. Each of the moments is 2 points, but the maximum number of points for the question is 10 points. Quite some students said that appeal to the Council of State for permits is also a way to influence the decision making. However, this was not awarded with any points because this appeal only relates to the technical permit issues and not to planning issues. The real appeal to influence the decision making is earlier with the Council of State, as you can see at the 3rd bullet point over here. And the appeal with the Council of State for the permits is not a real chance to influence the decision making, only relates to technical aspects of the road. The second correct answer, this relates to the land use plan. For the airport, a new land use plan needs to be made. Environmental groups will have to be considered interested party and thus have a legal standing. That is 1 point. There are 3 stages for influencing. Commenting to the pre-draft of a land use plan, 3 points. Submitting of views regarding the draft land use plan, 3 points. And lodge appeal with the Council of State against the land use plan that is adopted by the Municipal Council. Also 3 points. So this answer also would lead to 10 points in total. Let's go to the second question. Suppose that due to the new high-speed railway, the value of existing property in the neighborhood of the Amsterdam Central Railway Station rises. The city center becomes more popular to live in due to the neighborhood of the new high-speed line. The Minister of Infrastructure wonders, can some of the rise in value of property be skimmed off? She wonders, is it possible to tax or levy the owners so that part of the value is transferred to government? The question is, does the book Planning and Development Law in the Netherlands hold any instruments by which the rise in value of property can be skimmed off? Let's go to... No, there is no specific instruments to skim off the rise in value of property. 7 points. There is a general instrument to skim off the rise in value of property though. The regular property tax, also 7 points. This is the regular tax that has to be paid yearly by property owners. If the value of the property rises due to the infrastructure, logically, the revenues from the property tax will rise. Property taxes, however, can skim off only a little bit of the rise in value of property. That is because property taxes are low in the Netherlands. The topic of property tax is explained on page 11, and an instrument to compensate for the decrease, so not the rise but the decrease in property value, is in section 2.3 of the book. A number of students, excellent, pointed out that there is an instrument to compensate for the decrease, but there is no specific instrument to skim off the rise in value other than the regular property tax. You see here 2 times 7 points, but the maximum points that can be given for this question is 10 points. There were some alternative answers that were given points. Some students mentioned the tax increment finance that also was given 7 points. Actually, this is a form of property tax. Some students said a new tax is needed for this. According to the legality principle, Parliament must adopt a new law which gives the local government the power to set up such a local tax. That answer also was given 8 points. Some students referred to ground lease and said ground lease is indexed. Revision of the ground lease means that the leaseholder needs to pay more to local government. This is a way of skimming off the rising value of property. That is correct and was given 7 points, but of course it's only applicable in municipalities in which ground lease is used. Some students said, well, you should increase property taxes, 5 points. However, actually the increase of property taxes is not necessary because the property value increases and thus the revenues of the property tax. Some students referred to the instrument to recoup the costs of municipal facilities like streets and public parking spots from developers. That answer is not correct because the recoup of cost for new developments is different from skimming of the rise in value of existing properties. And the question explicitly directed towards skimming of the rise in value of existing properties. Okay, let's move to question number 3. What would be the rationale, so what would be the reasoning for government to skim off the rise in value of property? So, based on question 2, where the minister wondered, can the rise in value of property be skimmed off? Question 3 is, what would be the rationale, what would be the reason for doing this? Let's go to the answer. Well, the rationale would be that it is government who use taxpayers' money for the construction of the high-speed railway line, while the property owners profit from the rise in value without any contribution from their part. So the financial burden is one-sided, government, while the profits are for private individuals who did nothing to gain the profit. They automatically profited from the construction of the line. Under these circumstances, it can be deemed to be justified to transfer part of the financial profit from private property owners to government. The unearned increment can be transferred or should be transferred to government. That is the correct answer. And this is the. There were some alternative answers that were also given points. According to the Spatial Planning Act, the principle is that the costs of certain municipal services and public infrastructure facilities must be recovered from those parties who profit from the services and infrastructure. Well, this answer is worth 7 points and not 10 points because this principle aims at recovering the cost of local infrastructure from developers, whilst the question is about the rise in value of property of existing property owners. Another alternative that was given points. The government skims off the rise in value of property in order to be able to generate development or redevelopment that otherwise would not occur. This is quite a general answer. In itself, it's okay. Third, the principle of ground lease is that the increase in value of land must benefit future generations. Ground rent guarantees that money flows back to society. That's correct as well, but it's not a real good answer to the question. And finally, if decrease of value due to a governmental infrastructure or plan is compensated, and it is, see section 2.3 of the textbooks regarding planning compensation, it should be possible to do the opposite, skim off the rise in value due to a governmental infrastructure project, 10 points. This answer is excellent and is given 10 points. Actually, it is a rephrasing of the answer just given, the correct answer for question number 3. Okay, question number 4. If, after relocation of the airport, the land of Schiphol becomes available for planning, which tier of government has planning powers for the area? Is it the municipality of Amsterdam, the province of North Holland, the Minister of Infrastructure, or all of these tiers of government? Let's see what the answer was. Well, in principle, the municipality of Amsterdam, actually it is the municipality of Hoofddorp, adjacent to Amsterdam, has the prime planning powers. Article 3.1 of the Spatial Planning Act specifies that the municipal council has to adopt a land use plan. See section 4.3 of Planning and Development Law in the Netherlands. The land use plan designates to which purposes the land can be used. And as stated in section 1.4.2 and section 4.1 of the book, municipalities in the Netherlands have the most important powers. Applications for permits to build will be tested against the local land use plan, not against structure vision or other provincial or national plans. However, the province can have planning powers relating to the land in former Schiphol Area 2. If there are reasons that are of regional interest, the province can set rules for the development of land in advance through its general rules. It's explained in the book. 1 point. Likewise, the Minister of Infrastructure can have planning powers relating to the land in the former Schiphol area. If there is a reason of national interest, national government can set rules for the development of land in advance through its general rules, also explained in the book. 1 point. Well, if students all answered only all tiers of government have planning powers, well, it would be given 2 points because the answer is too short. It should have been more extensive. Finally, question 5. Everybody in Amsterdam wants the new residential area on the land of the former airport to be of high design quality, high aesthetical quality, good street, nice buildings, good looking streets. However, aesthetics of buildings and streets is something which easily leads to differentiating opinions. The question is, who, from a legal viewpoint, decides whether the new buildings and streets are of a satisfactory aesthetic quality? Well, from a legal viewpoint, it is the municipal executive, burgomaster and alderman, 6 points if you mention this, who decides about the aesthetical quality of the new buildings in the framework of their decision regarding the application of an environmental permit for a building project. 1 point. As I said earlier, any new plans for streets, for buildings are tested against the land use plan. The book explained that permits have to be submitted to the municipal executive and that the municipal executive decides. And there are certain points to test the application against. Okay, in doing so, the municipal executive takes into account the advice, 1 point, on external appearance, building aesthetics, given by the External Appearance Committee, 1 point. The External Appearance Committee will give their advice using the policy report on external appearance, 1 point. This policy report on external appearance is adopted by the Municipal Council, 1 point. All this is explained in section 361 of the book. Well, some students said, well, the municipality has the power to decide whether the buildings are of satisfactory aesthetic quality. That is not specific enough. 3 points were given. The correct answer is the municipal executive. Some students said, well, the municipal council decides. That's also partially correct because it's the municipal executive, as explained. The council adopts the policy document with the aesthetic rules. However, it is the executive who more specifically compare the building design with the aesthetic rules and has to decide whether or not the design is in line with the rules. Okay, well, in general, I am happy with the results of your work for this assignment. There were only few students with a grade below 6. Hopefully this has been a good exercise for you as a preparation for the exam and as a preparation for the other assignments. I wish you good luck with the coming assignments.